Dumelani sanibonani ninjani molweni afsheni thobelanda. Guys, today we'll be talking about South African constitutional law. You know, if you are doing this module CSL, it means that you are doing a South African constitutional law. Hi, I'm Tembiso Munyai, the best law tutor and journal writer. Before we continue, I want to show you this. This was the constitutional law which was written in 2024 in semester 1. If you can check this question paper clearly, this is something that you could see. Number one is that there was no question that was actually from the, many questions were not even from the book. And they want you to apply your knowledge based on the way you are learning the law. So it is very clear that when you go to the examination, you may find many new questions that you may have to apply with the law. It is very important for you to know the constitutional articles in general and things that are happening out there in the public every day. For example, question number 5 was about explaining the cases that was just recently adjudicated, which was the new national movement case. And then this case was just new, as I've said, and you have to be talking about this case. Okay, now today when we start with the CSL, let's start with the explaining the impeachment. Today we will explain the impeachment of the judges. We will start with the impeachment of the judges. Before we go on, you must know that from 22 July to 31 July 2024, I'll be giving classes and the joining fees and rent. If you want to learn constitution with me, you must take this WhatsApp number and WhatsApp me so that you can able to be the part of CSL. You are the part of learning CSL until the end of July. When we talk about the judge impeachment, you must know that a judge can be impeached by the JSC. JSC is Judicial Service Commission. A judge can be impeached by resolution which adopted in the National Assembly. And lastly, a judge can be removed from the case by a process called recusal. If you want to learn more about the recusal of a judge, removal of the judge, impeachment of the judge, you must open section 177 of the Constitution. Let's start by focusing on the recusal process. Recusal was best described by the Black's Law Dictionary, which is the process by which a judge is disqualified on objection of either party from hearing a lawsuit because of self-interest, bias, or prejudice. This is definition according to the Black's Law Dictionary. This means that each and every case, impartial of the judge is crucial. Judge must be impartial. Impartiality requires that the judge approach their adjudicative task with an open and unbiased mind, and that they suspend to the best of their ability the influence of their own ideology and political commitments when interpreting and applying the law. Impartial adjudication is indirectly safeguarded by the rigorous selection and interview processes that guide the appointment of prospective judges. And then there was the case that they said the case of the Safro. This case of the Safro was decided in the Constitutional Court, and it was heard that it must not be forgotten that an impartial judge is a fundamental prerequisite for a fair trial. Therefore, each and every trial is crucial for a judge to be impartial. Now, let's bring the cases that are related to recusal. The first case that you must look into is S and others versus Van Rooyen and others. This is the case in 2002. Van Rooyen was convicted in the magistrate court for theft and unlawful possession of a firearm and ammunition, and sentenced to imprisonment for a total period of 6 years. Van Rooyen appealed his conviction and sentenced to the High Court. One of the grounds of his appeal was that magistrate court lacks the institutional independence required by the Constitution. In this case, the Constitutional Court held that the judicial independence requires that judges must be able to hear and decide cases without any internal interference or influence. At an institutional level, this necessitates that there are structures in place to protect the courts against undue interference from both the state and private actors. How then is the independence of the judiciary preserved, considering that in terms of Section 178, subsection 1, the very composition of the Judicial Service Commission, the body which assists in the interviewing, there was much. This means that there's this case that you must look for in order to understand much about recusals, S and others versus Van Rooyen. That is the first case. I've already told you about the Safru case. And now we look with this Safru case, the test that was applied in Safru case to determine whether the judges was biased, impartial or not. The test which was formulated, which was affirmed by this case of Van Rooyen, which was reading, is whether a reasonable, objective and informed person would, on the correct facts, reasonable apprehend that the judge will not bring an impartial mind to bear on the adjudication of the case. The test is objective and must be properly contextualized, taking into account a balanced view of all the material information. The informed person posited in the test is thoughtful, aware, and sensitive to South African complex social reality rather than clinical, paranoid, or hypercritical of its past and present. Therefore, if you want to understand more about recusal, you will go and read this case and the case of Safru. However, we have many important cases international. Besides those two cases, there are cases of recusal application which was done in the Green Wallows Property versus Rogal Investment Company. Besides that one, we still have that case of Labour Court in Premier Food versus CCMA. It's another case that you can be reading about, knowing much about the recusal. Your argument can be also supported by international cases such as Vesta versus Knox City Council, which was done in Australia, in the High Court in Australia. You can read this case to understand much about the recusal. In brief, today we learn about the impeachment of the judges, which can be done by JSC and the resolution adopted in the NA, which the president will actually remove the judge. And then I said that there's a removal from the case or the legal proceedings if the judge, by the process of recusal, where the judge is recused. And I give an example of the case of S versus others Van Rooyen, which related to the recusal of the judges. And I told you that impartial is crucial in the legal proceedings. Without it, the case will be deemed, the judges will be recused. And then I gave another example by Safru case. And if you want to learn more, you can even learn about the case of internationals. Remember, from 22 July to 31 July 2024, I'm giving classes and the joining fee is just 100 rand. So if you want to learn more about constitutional law so that you can able to grab and understand this module before you even written some assignments or go into the examination, please WhatsApp me on this number so that you can join and able to have a fruitful week until the last 31.